If you're looking for an awesome product at a great price, be sure to check out the link in the description. In a major legal setback for ride-hailing giant Uber, the UK Supreme Court has unanimously dismissed its appeal against a ruling that will significantly impact the taxation of rival taxi apps. The decision means that private hire operators outside of London will not be required to pay a 20% value-added tax, VAT, on their profits. This landmark ruling stems from a pivotal 2021 Supreme Court decision classifying Uber drivers as workers, a classification that altered Uber's tax liabilities and obligations. Following this, Uber pursued legal action, arguing that private hire operators enter into a contract with passengers, a position initially upheld by the High Court in London in 2023. This favorable ruling for Uber would have resulted in a 20% VAT levy on operators. However, that decision was overturned in July of last year by the Court of Appeal, following a challenge from private hire operators Delta Taxis and the platform Vizu. Uber's subsequent appeal to the Supreme Court, delivered this Tuesday, has now definitively concluded in favor of the operators, solidifying the lower court's decision and delivering a significant blow to Uber's attempts to reshape the tax landscape for its competitors. The ramifications of this ruling extend beyond Uber, highlighting the ongoing complexities of classifying the gig economy and its associated tax implications. The case underscores a wider struggle to define the nature of contracts within the rapidly evolving landscape of ride-sharing services, with potential ripple effects across the industry. This decision follows a similar case involving Estonian ride-hailing and food delivery company Bolt, which earlier this year successfully contested the UK tax authority's claim on the VAT owed, leading to a ruling that Bolt is liable only for VAT on its margin, not the full fare. However, the UK tax authority, HMRC, has since been granted permission to challenge this Bolt ruling at the Court of Appeal, suggesting this area of tax law remains highly contested and subject to further legal battles. The Supreme Court's rejection of Uber's appeal marks a clear victory for smaller operators and underscores the ongoing debate surrounding the correct application of VAT within the dynamic digital economy. This legal battle has exposed significant inconsistencies in the interpretation of contracts and tax liabilities within the ride-hailing sector, potentially prompting a reassessment of existing legislation and regulatory frameworks. The complexities of this case highlight the challenges faced by both businesses and tax authorities in navigating the blurred lines between traditional employment models and the increasingly prevalent gig economy. The uncertainty surrounding these issues undoubtedly creates a climate of ongoing legal uncertainty for numerous companies operating within this rapidly expanding sector. The fallout from this Supreme Court decision promises to generate ongoing discussion and potentially reshape the future tax policies governing the ride-sharing industry, both in the UK and potentially internationally. Further developments and analyses are expected in the coming weeks, as experts dissect the full implications of this significant ruling on the broader landscape of the digital economy and its associated tax obligations. The long-term impact on both large corporations and smaller competitors remains to be seen, promising a period of significant change and adaptation within the UK's ride-sharing market. The ongoing legal battles, including HMRC's challenge to the Bolt ruling, suggest that this is far from the final chapter in this evolving legal saga. Observers anticipate further court cases and potential legislative changes as stakeholders grapple with the implications of this landmark decision. The Supreme Court's ruling is not only a significant legal victory for Uber's rivals, but also a powerful statement about the ongoing need for clearer regulation